We started a tradition last year with one of our favorite guests, that guest being Richard Winger, the publisher of Ballot Access News. Ballot access is one of the issues we think is the most critical in terms of incumbency protection, and we track ballot access issues through Richard Winger and his terrific publication, as I said, Ballot Access News. Last year we started something that I hope would become a tradition, and since we're doing it 2 years in a row, it's got to be a tradition by now. Richard has been kind enough and gracious enough to offer his time to give us kind of a year-round wrap-up of the highlights of what's going on in the world of ballot access. So what we're going to do today is start the first segment, which will be a conversation about litigation-related aspects of ballot access, and then we're going to do a follow-up segment on a subsequent show where we're going to look at legislation and other aspects of ballot access. So for today, again, Richard Winger, publisher of Ballot Access News, discussing the year's highlights in the world of ballot access and litigation. Richard, how are you?
Oh, thanks, Stephen. Nice to be here.
Well, it's hard to imagine a whole year's gone by since we last chatted, and I've studied every issue of Ballot Access News. So I want to see if the pupil is caught up with the professor here or not.
Okay.
So I want to start out by talking about interesting litigation. I know there's been a couple cases, at least one important case settled, and I know from your perspective far too many cases are not settled yet. So let's start out with what is settled. In Pennsylvania, we had an important district case that dealt with three aspects of ballot access. So can you walk us through that case?
Sure. Pennsylvania actually has had two ballot access cases pending, and the minor parties won one of them in July, and the state didn't appeal. And they won three issues, and since the state didn't appeal, that's all settled. The court struck down the law that bans out-of-state circulators and struck down the law that says the voter can't sign two different minor party petitions, and struck down the law that says every petition sheet has to be notarized. Now, there's a second case, and the minor parties won that one also, but the state appealed that one, so you can't say it's all over. But that was a very important issue. Pennsylvania alone among the states said that if a minor party or independent candidate turned in a petition and it was challenged and it was found that the petition didn't have enough valid signatures, then the group that turned in the signatures were liable for court costs of between $80,000 and $110,000. And that is so frightening to people that that fear caused groups to just not petition. And that's why in 2014, Pennsylvania was one of only 5 states that had a complete Democratic-Republican monopoly in the general election ballot for all the statewide offices. So winning that is a huge relief. And the other 3 are important too. We can talk about why they're important if you want.
No, I absolutely want to do that, but let's go back to the one you just brought up. Is that the Nader case?
No, that's the funny thing. Nader was the first victim of this system. It had never been done to anybody until it was done to Ralph Nader in 2004. And even though he turned in twice as many signatures as the state required, they required 25,000 in 2004. He turned in 51,000. But he was challenged, and they found he didn't have enough valid. So he was ordered to pay $86,000. And then they did it to the Green Party in 2006.
And so it's the Green Party that's challenging?
Well, technically, both of these cases in Pennsylvania had 3 plaintiffs. Both of them were the Constitution Party, the Green Party, and the Libertarian Party.
Okay. So going back to the original case I brought up, I think one of the more interesting issues is notarization. Because notarization is a problem around the country, correct?
There's only about 8 states that require ballot access petitions to be notarized.
But historically, almost every state did, and they're slowly but surely getting away with it, right? Or am I wrong again?
There's never been a majority of states that required it, but it is declining because it's dawning on people. It's just silly. There are some states, there's about 8 states, where the circulator doesn't even need to sign off at the bottom of the petition. In other words, the state doesn't care who the circulator was. And that's rational. All the state cares about is, did enough registered voters sign the petition? And you can find that out by comparing the signature in the petition to the signature in the voter's registration form. So why make a big deal out of who circulated it? Well, most states do want to know who circulated it. But, okay, so the circulator signs off at the bottom. Fine. Why? Why do you have to bring in a notary? What's the point? And it's very expensive unless the group has its own volunteer notaries, and you just can't become a notary public on the spur of the moment. You have to be trained and certified. So if you don't have your own volunteer notaries, it costs a lot of money. If you have to turn in 50,000 signatures, say that's 5,000 sheets, and the notary costs, in California, it costs $10 every time you use a notary. That's a huge amount of money for nothing.
Well, isn't that the point? That all these laws have been on the books for a while because they're trying to dissuade people from getting on the ballot. They want to throw up roadblock after roadblock after roadblock, but fortunately these roadblocks, thanks to your work and others, are slowly but surely being removed, correct?
Yes, because the Pennsylvania decision struck down the notarization requirement. We have a similar case pending in Illinois, and it could come out any time. I'm really hoping the Illinois case, which is a Green Party case, wins also.
Interesting. So there's a host of cases out there, at least two that I think you've reported on, I don't know if there's more or not, where people are trying to get access to the presidential debate structure. What can you tell us about those cases?
For minor parties and independent presidential candidates in this country, ballot access, as bad as it is not the biggest problem. A bigger problem is the Commission in Presidential Debates effectively keeping all minor party and independent presidential candidates out of the general election debates. So the only reason Ross Perot got into the 1992 debates is because President Herbert Walker Bush wanted him in the debates, and Clinton was okay with that. The Commission in Presidential Debates said Perot can't be in the debates, but when you have the Republican and Democratic presidential nominees saying, well, we want him in there, that rules the day. Because Ross Perot was only at 7% in the polls when he re-entered the race on October 1st, 1992. So he didn't meet the 15% polling requirement. But he got in anyway. He did very well in the debates, and that's why he got 19% of the vote. But nobody running for president other than the Democrat and Republican has been able to be in the general election debates since. So there's two lawsuits pending against that. One of them was filed by Gary Johnson and Jill Stein, and that's suing the Commission in Presidential Debates directly on antitrust grounds, because these debates have a huge economic impact on the community that sponsors it. It's a big, big deal. And one of the aspects of the Commission in Presidential Debates habits is they require the people they do invite to sign an agreement that they will not participate in any other general election debates. Now, that's totally unlike the primary season debates, where lots of sponsors put on presidential primary debates. We've seen that in the last few months. I think 4 different networks have sponsored these things. But conceivably, somebody else might want to sponsor a general election debate and invite the Democratic and Republican nominees and leading minor party and independent presidential candidates. But they can't, because the Democrat and Republican have already signed papers saying they won't do that. So they have a monopoly. So I have my hopes up that this case can win.
What's the argument in the case? Is there a constitutional argument, due process?
No,
the argument?
The 19th and early 20th century federal laws on antitrust, the Clayton Act and the Sherman Act, that's the basis for it.
Antitrust. Has this issue been heard anywhere else, a similar issue, or is this de novo?
No, this is the first time this argument has been tried. There's been lots and lots and lots of cases in presidential general election debates with all kinds of theories, but nobody's tried this theory before. But we've had lawsuits like this even before the commission and presidential debates existed, the League of Women Voters used to hold them. So some of these cases started in 1976, 1980, 1988, 1992, 2000. So there's been a lot of them. But another reason I'm optimistic about this case is we've seen so many presidential primary candidates participate in the Republican debates this year. I think one of them had 11. I know several of them had 10. I think the one last night had 9. And they work. I mean, people might have thought it's impossible to have a good debate with 8 or 9 or 10 people in it. But they've been proven wrong. These debates are very popular. They get a high viewership, and they really do a good job of educating the public about each candidate. So the commission really, I don't know what kind of arguments they're going to make.
So what would be the timetable? They'd have to have a decision by, what, next July?
Oh, no. The first debate isn't until late September.
Okay.
And, you know, there was in 2006, there was a federal judge who told a TV station in Florida that they had to admit the Reform Party candidate, Max Lynn, into the gubernatorial debate. That decision came down on the morning of the debate.
Awesome.
And so they put another chair in the room. It was no big deal. These, unlike ballot access cases where they have to print the ballots in advance, you can have a good decision on a debate right before the debate.
So I know you've been concerned this year that there's a bunch of cases that are taking too long to be decided. Can you walk us through that and what the basis for your concerns are?
We've got about 17 states with constitutional ballot access cases pending, and some of them are as much as 4 years old. And here the election is coming up. And the candidates and the parties need to know what the rules are. And I understand the federal judges have too much work. There's not enough federal judges. It's partly Congress's fault. Obama nominates people for judicial vacancies, and Congress just does nothing. So the judges have too many cases, but it's getting remarkably bad. I mean, the worst example is a case the Libertarian Party of Illinois filed in 2012, 4 years ago almost. And it still hasn't got a decision even from the U.S. District Court. It's a fairly simple case. Illinois has an odd law, no other state's ever had such a law, that a new party must run a full slate of candidates. So if a new party wants to run for president, it must run somebody for U.S. Senate. If a new party wants to run for county assessor, they've got to run for all the other county executive positions, including, you know, district attorney or prosecuting attorney. And the party may not have a willing lawyer. Why should a party be forced to run for offices that it doesn't want to run for? Furthermore, this law is discriminatory. It doesn't apply to the old parties. So I don't want to criticize this U.S. District Court judge by name, but she has an odd habit of saying when she's going to release the opinion, and she has 10 times set a date on which she would release the opinion, and each time when that day comes, she says, okay, I don't have it, and then she sets another date.
You know, Richard, it's interesting you bring up Illinois, and I know you read my first book many years ago, but that was one of the twists in my book, that I had created this new fictional third party called the E-Party, and they then became forced to run a full slate of candidates, and that was part of my story in my book. So it's interesting you would recall the Illinois law for me. Thank you. You know, it's interesting. You have this amazing repository of knowledge and wisdom and facts that you always bring up on the show. That's why me as a student can never keep up with you as the professor. You're amazing. The one other suit I wanted to talk about is the one in Kentucky dealing with the definition of a ballot qualified party. Tell us a little bit about that case.
Kentucky's the only state in history that ever defined a qualified party strictly by its vote for president and nothing else. In Kentucky, a qualified party is one that got 2% for president in the last election. And if you don't do that, you can't be a qualified party. So the Libertarian Party and the Constitution Party have recently filed a lawsuit saying that's just too restrictive. It doesn't make sense because there's many parties in this country organized in just a single state that are not interested in the presidential race. So they couldn't get recognized in Kentucky. There's so many things Kentucky could do. They could say a qualified party is one that has, say, 2,000 registered members. That would be easy to do because Kentucky kindly keeps track of how many registered members there are in each party, even if they're not on the ballot. Or they could simply do what most states do, say a party is a group that got 2% for any statewide race. So we'll see what happens.
You know, it's interesting, Richard, as I'm listening to you today, and it's a great interview, you mentioned Pennsylvania, and then you'll say, and Pennsylvania is the only state in the country that has this, and Illinois is the only state in the country that has this. Kentucky is the only state in the country that's this. It just makes you think there's this conspiracy theory out there where each state has gone out of their way to find its own unique way to create an obstacle that, you know, independent and third-party candidates just can't get past.
Yeah. One of the distressing things is that the state legislatures don't really pay much attention to the ballot access laws of the other 49 states. But what's really more important is for federal office, there ought to be one standard for getting on the ballot for federal office. There's 3 political scientists from Canada who put out a book called Establishing the Rules of the Game. And it's a great book because they tried to get all the ballot access laws of all the democratic countries of the world and print it in their book. And they did. But they left out 2 countries. They left out Switzerland and the United States because they said, in these 2 countries, there is no single law for how you get on the ballot in the national elections. Instead, each subdivision of the country writes its own law, and that's just too messy and complicated, so we had to leave these countries out of our book. We should really have a federal standard for getting on the ballot for federal office.
Wonderful commentary on our democratic process. So we're going to run out of time. Before we do, I always like to have you give a little free PR for Ballot Access News. Tell the viewers how to find you and how to subscribe and how to get great value.
Well, 30 years ago, I started Ballot Access News as a print publication, a monthly, and it carries on. And I crave people to subscribe because there can't be a newsletter without subscribers. I have about 650. It would help if I had some more. It's only $16 a year for 12 issues. And you can see the old issues on the internet, but I don't put up the new issue until it's a month old. But if you want to look at the old issues, or if you want to see my blog and you want my contact information, just go to Ballot Access News, which you can Google, or the exact address is ballot, and then a hyphen or a dash, access.org. So again, I'll say it, ballot-access.org.
Richard, I've told you many times, not only are you an amazing guest, an amazing historian, but Ballot Access News to me is an all-time great value. And I don't know how you get away with $16. I shouldn't say this because I'm a subscriber. If you tripled that, I'd be signing up. So anyway, thanks as always for your time today. And we'll catch up with you next year for another review of the world of ballot access and litigation. Thanks, Richard.
Thanks, Steve.